No will, no problem. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine the very common set of circumstances where somebody dies without a will. Is it a problem if you have no will? Well, it depends. The term that is used for somebody that has died without a will is called intestate, and the laws of intestacy are those that govern those rules. So what does it mean when you die without a will? Well, first of all, it is a very common set of circumstances. Many studies show that between 30 and 67% of Americans have a will. I think that's a bunch of nonsense. I think a much smaller percentage of Americans have a will, somewhere about 10 to 15%. Most people die without a will. Now, a will, of course, is the roadmap. It provides the instructions for how the personal representative is going to manage and handle the financial affairs of the person that died. And when you die without a will, you're really leaving it to a set of statutes. Those statutes are set forth in a statute book, and there are charts and tables that direct and identify the distribution pattern. So for example, if there's a surviving spouse, are the children children of the surviving spouse, or are the children not children of the surviving spouse? Depending on those circumstances, the government has identified a set of tables that dictate the percentages that that person will receive. So for example, using the chart here, if you die intestate and there's a surviving spouse, the spouse's share is the first $273,000 of someone's estate. If the surviving spouse had no children with the decedent, that number drops down to $182,000 in year 2023. So this is just a simple set of tables that dictate how the distribution pattern is going to be if you have no will. Now, for most people, that may be an issue. They may not want the first 100 and some odd thousand or 273,000 to go to the surviving spouse. They may want more. They may want less. So that is why the writing of a will allows you to determine the distribution pattern rather than what the government thinks should occur. Here's a very common set of circumstance. The decedent dies with no spouse and 2 children. One child is deeply and actively involved in the person's life. The other child is estranged and hasn't had connections or communications with the person for many, many, many years. The person dies with no will. The statute of intestacy provides that the 2 children are treated equally. Now, surely the person that died would not want that to occur, but the government, through the laws of intestacy, doesn't know that. It can't discern the different levels of relationship between the 2 children. So, of course, we strongly recommend and urge you to do effective estate planning to ensure that you can identify how you want your distribution pattern to be, rather than the laws of intestacy dictating who gets what in what share. Now, whether you have a will or no will, if the assets are owned by the decedent and there's no joint owner or no named beneficiary, those assets are going to go through probate. A common misconception is that if you have a will, you avoid probate. That's just simply not the case. So with a will or without a will, they both go through probate. So if the laws of intestacy are simply going to meet the intention of the decedent, then having a will doesn't really add much to the conversation. It may direct who's going to be the personal representative, but it may not alter the distribution pattern. And then on the other hand, if the laws of intestacy don't identify the intention of the person, then it's really important to create a will. At the Probate Pro, we strongly urge that you work with a skilled, competent probate practitioner to guide you through these issues, whether it's before death, with the creation of an estate plan, or after death. If you have more questions, reach out to us at 833-PROBATE or visit us at theprobatepro.com.